You're on, like everybody else should. Good morning. Welcome to meeting number 1 of the Budget Review Subcommittee on Human Resources. As a reminder, we have new meeting protocols in place for 2022 interim session. No remote attendance by members is permitted by the 2022 interim session. All members must attend in person to be recorded as present. The meeting materials were put online earlier this week and made available for downloading. At this time, we'll have the Secretary call the roll.
Senator Rocky Adams. Senator Alvarado.
Here.
Senator Berg. Senator Carroll.
Here.
Representative Bowling.
Here.
Representative Fleming. Representative Gordon. Representative Gibbons-Prunty. Representative Sheldon. Representative Weber. Representative Westrom. Representative Wilner.
Here.
Senator McDaniel. Representative Petrie. Representative Reed. Representative Moser. Co-Chair Meredith.
Here.
Chair Bentley.
Here. We have quorum. Okay, we have a quorum. Okay. This morning we're going to get on an overview of the funding provided to Kentucky through the opioid settlement from Chris Lewis and Brian Hubbard with the Office of the Attorney General. And who else is out there? Be sure you turn your speaker on when you speak.
Blake Christopher, also at the Office of the Attorney General.
Okay. So, Chairman Petrie over the budget came to me and he said, we need to get this information out so the public would know what's going on. So that's the reason we've called you in here this morning. So at this time, I reckon, Chris, you'll be starting. Chris is the Executive Director of the Office of Consumer Protection, or Office of Attorney General. And the overview of this funding is provided to Kentucky through the opioid settlement through the Office of the Attorney General. So hold your questions, and after the presentations, and you can begin.
Great. Well, thanks for the committee for having us here today. Start off with slide, I believe it's slide 3 of our presentation, with the big 3 Johnson & Johnson
Please
settlement.
identify yourself again for the record. I'm sorry. It's my fault.
My apologies. Chris Lewis, the Office of the Attorney General. So the first slide that's up, you'll see the big 3 Johnson & Johnson settlement. And of course, when we say big 3, we mean AmerisourceBergen, Cardinal Health, and McKesson Pharmaceuticals. That's resulted in a combined total of $478 million that will be coming to the Commonwealth. It was a result of a $26 billion global settlement with the vast majority of the states and territories in many of their political subdivisions. House Bill, go ahead. No, you can advance. Looking at just the distributor settlement, it's important to remember that these are 2 separate settlements, even though we've kind of talked about them as one because they were done as a package deal. The distributor settlement provides for a total of $388,330,000 and change to the Commonwealth. Because of the legislation that was passed, that is split 50-50. So the portion going to the cities and counties will be $194 million and change, and the same will go to the Opioid Abatement Commission that was created by statute. This shows how those payments will flow. There is a larger payment in the first year, mainly because it will all be received in July and August. So that's $16,589,000 and the $17,434,000 will all be coming at about the same time once the administrator has worked out, the process of getting the checks out the door. It'll vary by year after that. Years 2 through 3, we'll see $17 million in change. 4 through 7, $21 million. 8 through 10, $25 million. And then 11 through 18 will be, again, about $21.5 million a year. Going on to the Janssen, which is the Johnson & Johnson settlement, Janssen is a little different. Because Kentucky got the statutory bar in place, we are eligible for kind of a bonus payment as they see it. They are giving us the first 4 years of payments in one payment. So years 1 through 4 will be paid up front, and that'll be an initial funding of $47 million, 47, close to $48 million coming in. Total to the state, $23,847,000 and change, going to the commission, and the same amount to the cities and counties. The kicker with that, they are paying those first 4 years up front. They're not taking a discount for early payment, but we will not see another payment from the Johnson & Johnson settlement until 2025. So one thing to keep into mind is, we will get that huge first influx of cash from them, but there will not be another payment until July of 2025. So this slide shows the combined settlement totals. This is Johnson & Johnson and the distributor settlement together. And you'll see in July of 2022, that initial payment with the combined will be the $32,564,000 as the 50%, and that $8.294 million above it will arrive at approximately the same time. And this lays out over time how those payments will carry forward. You'll notice that the amounts get smaller beginning in 2031, 2032. That's because Johnson & Johnson is paying out over 11 years, whereas the distributor settlement is paying out over 18. So we'll have that larger amount coming from the two settlements up front. After 2031, it will just be the distributor payment that continues to play out. So as we discussed before, 50% of these funds will go to local governments, the other 50% to the Commonwealth. The settlement checks will be issued by the national administrator, who was selected as part of the overall national settlement. A list of the cities and counties qualifying for direct payments will be submitted to them. Those checks will flow directly from the administrator to those local governments. Same with the check that comes to the Commonwealth. 22 RS Senate Bill 90, of course, $10.5 million has been earmarked for behavioral health and development and intellectual disabilities budget. And I believe that is to kick in January 1. So that will be one of the first expenditures that rolls out of the state's portion of the settlement. All funds, whether they're local government funds or the commission, have to be used for opioid abatement under the settlement. And local government recipients of commission funds, and actually local government recipients of funds from the settlement, will be submitting annual reports to the committee to track how that spending is going, how it's being used, and hopefully to track some of the outcomes so we have a better idea of what's working and what's not. And I'll turn it over to Brian now.
My name is Brian Hubbard. I am the chair and executive director of the Kentucky Opioid Abatement Advisory Commission, and the next few slides will be covered by me. The Kentucky Opioid Abatement Advisory Commission has been established by 21 RS House Bill 427 and codified at KRS 15291 and 15293. This commission will oversee the Commonwealth's 50% share of the settlement proceeds. Its composition is set by statute, includes 11 total members, 9 are voting, 2 are non-voting. The voting members serve 2-year terms after initial staggered terms, and the non-voting members serve at the pleasure of the Senate President and Speaker of the House. The members of the commission who have been appointed by Attorney General Cameron are Dr. Jason Roop of Campbellsville, who represents victims of the opioid crisis, Van Ingram of Frankfort, who represents drug treatment and prevention, Vic Brown of London, representing law enforcement, Ms. Von Purdy of Louisville, representing citizens at large, and Ms. Karen Butcher of Georgetown, who also represents citizens at large. And I, again, am the Attorney General's designee. Other members of the commission prescribed by statute are Treasurer Allison Ball, Representative Danny Bentley, who serves as chair here of Russell, has been appointed by the Speaker of the House, Karen Kelly of Somerset was appointed by President of the Senate, but I received her resignation yesterday evening late, and she is going to be replaced by Mr. Carlos Cameron. We also have Dr. Sharon Walsh of Lexington, appointed by UK's Healing Community Studies team, and then CHFS Secretary Eric Friedlander or his designee. In terms of the Commission's work for the remainder of this year going into next year, we will have meetings and listening sessions in late summer through the fall to take place in locations throughout the state. The first meetings that will address drafting and publishing of regulations, with the first meeting occurring on July the 12th. KRS 15291 will allow the Commission to issue regulations on an emergency basis, and we expect to have an online application process ready by the end of 2022, with applications submitted for review and awards starting in 2023. Any questions?
Representative Weber?
Good morning, gentlemen. Thank you for this presentation. I had a chance to hear it last week, but a lot of good information in there that I want to follow up on. After that initial meeting, I've received some feedback from local officials, specifically a city official. I'm sure county officials may be reaching out at some point as well. One of the questions that they had is, it was their understanding that any previous expenditures or activities that they've had would not be covered under this opioid abatement settlement. Is that correct? Is there a way for them, if they've engaged in an activity that is properly documented, that they can provide the receipts and other documentation? You know, can they apply that to the settlement cost and recoup that money? And I was wondering if one of you could address that for me, please.
So I think the best answer to that is probably to say it will depend on the kind of past expenditure. House Bill 427 provides that the Commission and the local governments can, generally speaking, spend opioid settlement dollars on opioid abatement that is in two categories. One of those is future projects, and the other is for reimbursements. The statute sets out, I think, about three different subcategories of reimbursements that are permissible. What I would suspect, and those three are, I'll read them real quickly, any reimbursement for costs related to outpatient and residential treatment services, emergency response services, and any portion of the cost of administration of naloxone, which I think has been since changed to cover any generic version of that drug as well. And so those are the very specific categories set out for reimbursements. I would suspect that there will be there may be further detail in terms of what the reimbursement requests look like, what documentation may be necessary that may come in the form of regulations in the near future, in terms of how far back you can go, what kind of documentation you need. So I suspect the Commission may have an opportunity to address that via the regulations.
So with regard to the official that contacted me and any future folks and other members of this committee, who should we direct them to get clarification on that at this point?
Just to be sure we don't run into any conflicts, I think you're fine to send them to Chris or I, either one, and we can help direct answers from there.
And I will say, I don't know which jurisdiction you're talking about. Many of the local governments were represented by council. If it happens to be one of the litigating subdivisions, they probably need to go to their council first, because there would be a conflict of interest with us giving them advice related to this while they're still represented by council. If they were a non-litigating subdivision, we're happy to talk to them and answer their questions.
Okay. Thank you. I appreciate that response.
Representative Bowling.
Thank you, Mr. Chair. My question comes from how the settlement was derived. Like, what what numbers did you all bring to the table as far as, the cost to the Commonwealth, the cost to local governments? Where was the starting point on that, and then kind of where did you ultimately land on an agreeable figure?
It's a little complicated the way this all worked out. The formula that was arrived at was originally arrived at within the MDL. Judge Polster up in Cleveland, who was handling all the local government settlements, all the private party settlements, appointed a committee to look into the overall cost as best they could attribute it across the United States as a whole and within particular jurisdictions. They looked at the amount of opioids that were sold in the area, the amount of deaths resulting from opioids, and came up with those, I guess you would think, enhancing factors. The other factor that was taken into account was the population of each state. So, for example, Kentucky, usually under population-based settlement in a national settlement, would qualify for about 1.09%. In this particular settlement, we were up over, I believe, 2.1 or 2.3% because of those enhancing factors, because of the concentration of the opioid epidemic in Kentucky, the additional lives lost, and everything else. And so that entitled us and several other states to a larger share, whereas some of the states where it wasn't as intense actually gave up a percentage of their settlement so that money could be shifted to the states that incurred more damages.
I'll just add to that real quickly, if I may, and Chris can correct me if I misstate any of this, but 427 itself, I think, played a role in, if not the ultimate number, certainly in the distribution of that number. And he mentioned up front that 427 allowed us to get, at the very least, that J&J portion, the first 4 years paid in one lump sum. There's no discount to J&J for that lump sum. The benefit is to us to having received it up front as a consequence of 427.
Okay, so it was more derived from just basically the amount of opioids in a region, in an area, not so much the actual local government costs to what they were, having to increase in corrections and in policing, that type of work.
That's part of the severity factor that was taken into place as far as submitting actual numbers from that. Because this was a abatement public nuisance type case, it wasn't necessary to pull all of that together. It's really what is the cost of trying to solve this going forward. Had it been a straight tort action, then yeah, all those numbers would have had to be brought together to kind of justify the underlying damages. But under the public nuisance abatement theory, it's a little different. It's, admission that the problem is there and what can we do and what's it going to cost us to try and get a handle on it.
Thank you very much. Thank you, Mr. Chair.
Thank you, Representative Alvarado. I worked with Dr. Dorado.
Thank you. It all sounds the same. It works good. Gentlemen, thank you for your presentation. Just really quickly, I'm always curious when these kind of, I know these distributions come out, what if any of these stakeholders, I guess, if any of the distributors or the manufacturers go bankrupt, what happens in terms of funds? Is there some protection for that? But if they declare bankruptcy in the midst of all this, I would imagine we're one of many states this has been settled in, so it's a large sum of money. I know some of these can have very deep pockets, but if they do declare bankruptcy, what then?
Always forget to hit the button. If they do declare bankruptcy, I believe there are, and I'd have to look back at the individual settlements because, again, they are two different settlements. There are provisions that try to address that. Ultimately, it's going to be up to a bankruptcy court. It's not as big a concern with the distributors in J&J because they are, such deep pockets. There are, of course, others inside or other defendants in some of our opioid cases where it is a concern whether or not they'll end up in bankruptcy. Of course, we know Purdue Pharma is in bankruptcy. We're participating in that, have a proof of claim on behalf of the state. That's still being worked out in the Second Circuit Court of Appeals. Mallinckrodt was another company that went into bankruptcy. That bankruptcy has been finalized, and the effective date has occurred. And that's going to result, and again, these are all a little different. In the Mallinckrodt case, there are three options for Mallinckrodt to pay out of the bankruptcy. One is an 8-year plan, in which case over 8 years the state will receive $21.8 million. Another is a year-and-a-half plan, in which case we'll receive $15.9 million. They also have the option to pay off in year one after they emerge from bankruptcy, which would be $15.3 million. So that one actually does take a time value of money into account. And they were a much smaller player in the market. So that's, I think, the kind of thing we can expect if we end up in bankruptcy. There will be some provision with the liquidation of the assets if it's a complete liquidation of the company, or in the restructuring, it'll be much like Mallinckrodt, where the monies that are still owed, they'll have to come up with a payment plan for that, for the payments remaining in the states. And that'll be a matter of financing as they emerge from the bankruptcy process.
Senator, if I may add to that, and thanks to the General Assembly last session, there's a piece of legislation that became law that will ensure that no matter whether it's through a bankruptcy proceeding or through a regular settlement like we had with the Big Four or Big Three and Johnson & Johnson here, that broadly speaking, that money will be spent the same way, right, and go according to the same plan in 427. So whether it comes through a bankruptcy proceeding, whether it comes through a settlement like the Big Three and J&J, as long as it comes out of that Middle District lawsuit, it will be spent according to the plan in 427.
Anyone else have a question? Oh, okay. Representative Westman.
Wow, I think this discussion could last 3 days. And I think it boggles the mind to even consider what the profit margins were for those lumped together companies during that period of time when so many people were falling. My first question is, are there any death benefits for the people who died from their offerings?
So there were private lawsuits, and private lawsuits are a separate part of the overall settlement. It's not a part of the Commonwealth settlement. So, to those that had claims, that filed claims, there is a provision for that that is outside of the $26 billion settlement that was done. It's for the private plaintiffs, parties that were out there. But that is not part of the portion of the money that's coming to the Commonwealth.
That's very good to know. Another question?
Yes, ma'am.
Will these dollars that come in, will they be funding any treatment programs that are currently in place, or will new ones be built, or do you have an answer to that?
Right.
So as we discussed at the outset, half of this money will go to the cities and counties for the specified purposes set forth in the statute that established this commission, and that is opioid abatement in a very broad sense. That certainly encompasses treatment. Treatment will be encompassed within the mission of this commission insofar as it will be reviewing grants for the distribution of these funds to address the ills that have come with this mess.
I know we've had I can't even imagine how many treatment programs that have opened up over the last 7 or 8 years. And I'm very hopeful that I know many of the treatment programs are wonderful and there are great outcomes. At some point, I would think this addiction would be diminished in number. But I'm wondering if we would be expanding programs that ultimately will have to close because funding sources are diminished. Is that going to be a problem, or will that be a wonderful problem?
Well, insofar as we make a measurable impact on the problem and no longer need the scope and scale of treatment programs that we have, that certainly is success. Insofar as there is a question as to a continued funding stream, insofar as this commission's resources are finite, Medicaid provides coverage for many of these addiction services for the population that statistics bear out is ground zero demographically for this problem. And insofar as that is the focus of our efforts, that money should continue to be there unless there is some unforeseen change to Medicaid coverages that would inexplicably disqualify that treatment.
Well, I have to say that it's deeply encouraging to me that 10 years ago, if people died of an overdose, their families were mortified and shamed. They were embarrassed. It was something you didn't talk about. And now it's a topic that people freely discuss and learn about so they can be aware of what's happening in their own community or their own families. It's refreshing to know that something so horrible can have some good outcomes for the public. And I think we have seen that. We still have a lot of growth to go, but it'll be very interesting to see the outcomes as time goes on. Thank you.
Thank you.
Senator Meredith?
Thank you, Chairman Bentley. Appreciate you guys being here this morning. My question deals with the 50% that's going to city, county, urbans, and I'm reading specifically from the bill here. It says that the proceeds will be distributed in accordance with an agreement reached among them that incorporates the criteria, them being city, county, urban group. What's the vehicle for bringing these folks together? Is that going to be done through the KCO, Kentucky League of Cities, or how's that work?
I think that section's been modified in the new bill, Senator. If I recall correctly, the distribution under the bill that was passed this past session actually uses the national metrics to determine what the allocation will be to each of the litigating subdivisions. It set a threshold that any subdivision that was receiving less than $30,000 out of a single settlement would have its money roll up into the county government for that particular locale. And so that is being worked out into what's called Exhibit G, which is to both settlements. Exhibit G lists the specific local government entities that are entitled to receive direct payments. That is something we are still working out. And to answer your question, we have been working with KCO and KLC, along with the plaintiffs' attorneys who represented individual governments, to come up with an agreement as to how that rolls up given the statute and that $30,000 threshold. It has presented a quick problem that we're trying to work out, in that Exhibit G lists local governments that are entitled to receive direct payments. However, they can't receive those direct payments until they have signed a participation agreement with the settling parties. Because we expanded the number of local government entities that would receive direct payments, I believe we have about 77 who never signed participation agreements, and we're working to get those finalized now so they can receive the direct payments. But it has all been a combination of work with the litigating attorneys for subdivisions, KCO and KLC, to kind of come to that agreement as to what that exhibit looks like and which entities will receive those direct payments.
Mr. Chairman, follow up, please.
Yes, sir.
I would think once this has all been established, I can envision maybe just an onslaught of requests for reimbursement, and I would think probably you're going to have a tsunami of requests for funds. Will that be on a first come, first served basis? Is there a per capita limit for these political subdivisions? Or
Well, now, the subdivisions, of course, will have their own funds. If they choose to allocate some of that to reimbursement, I believe they can do that. They'll have to be careful. One interesting thing about this settlement is, since so many local governments are receiving direct payments, we're a little bit separated in the settlement going forward. So the state's portion will never be affected if there is a violation of the terms of the settlement agreement. Individual cities and counties can. So, they're going to have to consult and really think about whether what they are reimbursing themselves for qualifies under the statute, qualifies under the settlement, because that individual local government entity could see their payments clawed back if they violate those terms.
it looks like there's just a heck of a lot of work that's going to have to be done to get this into place. And as part of that, is there any accountability? Because you said what bothers me is the clawback. Is
Sure.
We've done this, but now we're going to take the funds back, and mean, I appreciate we have all this money, and certainly we want to see this problem addressed. But if we're not getting any results, then I can see it's all for naught. But again, a lot of work.
I'll add two things to that. One is the commission will have the opportunity, if it wishes, to issue some guidance through regulation on the reimbursement issue. Now, largely speaking, that will be about the commission's side, right? But could certainly provide some guidance to counties and cities, indirectly, right, on the kind of reimbursements that you're talking about. The other thing is, accountability is an extraordinarily important issue here, and we want to make sure, not just for purposes of keeping the settlement intact, that the money's going where it's needed, but also because it's, I think, quite frankly, a matter of life and death, that these monies get to where they're needed most and get there directly and aren't wasted. That everybody is good stewards of these resources, and they're used in the best way to do the most good. The statute lays out a specific process, at least initially, for that accountability to take place, and that's through the regular certifications that even the local governments have to submit. So every recipient of the commission's dollars and every local government that receives money directly from this settlement as part of their 50% share will have to submit a regular certification to the commission saying, generally speaking, this is what we spent the money on, and this is how it's related to opioid abatement. And the commission will have, the authority to review those and so on and so forth. But there will be a documented record, right, that will have to be submitted on a regular occurrence. I think the statute says no less than annually, to provide those kinds of.
That comes back through A&R on the legislative side. Yeah.
Does that give you a little bit more?
It does, and I would probably encourage the commission taking a broader role in this, because there's kind of an inherent conflict of interest, I think, with the cities and counties, because they're going to want the money, obviously, and many are desperate for money. And I think to have any kind of independent review of this, it almost have to be from the commission itself rather than that group. But I guess we're open for discussion, consideration at this point, because nothing's been finalized. But another thing I don't want to do is see us create a bureaucracy that's so burdensome that folks just won't even try. Then
Right.
What do we do? So,
And I'll add, Senator, another layer to that. The money that is being provided, as it's spent, there has to be reporting to the national administrator in the overall that is, working for oversight nationwide. So they will be tracking how the money is spent, if it's being spent for the, agreed upon purposes. And if any money is allocated for anything other than abatement, there has to be a specific filing with that national administrator explaining why and what it was used for, and an explanation of how it fits into one of these other exceptions. So that'll be another layer of oversight outside of the state.
And
well,
Senator,
that pending bureaucracy is starting to scare me just a little bit, and I'm afraid we may be spending a lot of resources just trying to comply without really understanding what we're complying with. But again, I understand this is a process that's being developed, so I'll be anxiously awaiting to see where we go with this. But thank you.
if I may add one line or two to what my colleagues here have had to say. Insofar as the commission can play a constructive and helpful advisory role to the localities as they figure out what that money should be used for and can be used for to gain its maximum impact, we will absolutely take that role. The one thing we don't wish to see is either an expenditure of resources for naught, unnecessary replication, or a failure to cooperate among localities who are strapped for resources. We want to make sure that we're able to maximize the impact of these dollars by making sure that they go to the right places in the hands of the right people, and that all of those expenditures are tracked, transparent, and available for public inspection on demand.
I appreciate that. I think that could almost become the mission statement for the commission. And if we can keep it to a one-pager that everybody understands, it certainly benefits everyone. But thank you. I appreciate that.
Senator Carroll.
Thank you, Mr. Chairman. Gentlemen, thank you for the presentation. Most of my questions were just answered. The concern through all of the issues with opioid and the state's approach is the coordination of efforts and being able to monitor the success of the efforts that are ongoing. This is a little bit scary, that money going to cities and counties and doesn't really sound like that there's an overall plan and an overall coordination with these new efforts and with the current efforts to ensure that these are the best investments we can get, and they're on data-driven practices, programs. And can you all speak to that a little bit, of the overall efforts in the Commonwealth to fight the opioid epidemic, and how the existing efforts will be coordinated, if at all, with the funding from these settlements? It's a little concerning that it's too piecemeal and too fragmented.
So if I understand the question correctly, it's maybe two parts. One is how do we measure results, right? So how do we determine if a project is working, right, or not, and ensure that money's going to projects that are working? And then the second question is, how do we make sure that money is being spent efficiently by making sure there's no replication and
Yes.
things of that nature?
Yes.
So I'll talk about the second question first, which is, to some extent, right, the 50-50 split is, I would imagine, I don't want to speak for the legislature, but intended to sort of empower local communities to provide local solutions, right? Because what may work for Louisville or Lexington, right, in terms of opioid abatement, might not work for where Brian and I are from in Eastern Kentucky. And so I think that's part of the driving force there, is to provide ground-up local solutions to the local problems that cities and counties are experiencing. But again, I can't speak for the cities and counties, and I certainly can't speak for what the legislature had in mind when it passed. On the other hand, I think there is absolutely an opportunity for the commission to provide a sort of counseling sort of role here and connect ideas and people together, and to do big things instead of piecemeal approaches, right? To connect people who have big ideas with other people who have needs for big ideas. There's also going to be, I imagine, future settlements that will come in to the 427 plan that will have to be spent on regional appropriations. So it will be part of the settlement where money is spent in bigger geographical areas and on larger geographical bases, right, than just individual municipalities. But I absolutely think the commission can, to the extent it desires to, play a role in connecting, hey, we received an application for this. We've also received an application for this. These two people should get together and get in a room and figure out a way to put it into one to cover a larger area and do so more efficiently. I think the same thing can happen, right, with information sharing among cities and counties with the commission, and with the commission to cities and counties, to ensure that a grant's not being given to do a project that's already being done on the state level, right? That can be done through the application form, right, and making disclosures and say, where are these projects currently taking place? Have you asked for money from the cities and counties before coming to the commission, and vice versa? So I think there are mechanisms to handle that, if that helps answer your question. And then the reporting, I think, to your initial first part of the question on how do we ensure that the projects are working, I think that's done through the reporting mechanism, right, where we can put on that reporting form, that disclosure form, here's what you got money for, here's what's being spent on, and then give us a contact, right, that we can follow up with and ensure that it's working. Give us a measurable, right, that we can ensure that this is in fact working, despite what's being disclosed on the form. Does that make sense?
It does. Do you all feel comfortable that the infrastructure that's in place from the legislation is sufficient to get the most effective use of this funding?
I guess, are you referring to the commission itself as the infrastructure?
In all facets of this, do we need to look at further legislation to narrow down the focus of this funding to ensure its most effective value?
In terms of how the statute defines the purposes for which this money is to be used, in my individual judgment, that statute is very well written and all-encompassing and yet specific. To get to the heart of what I think your concerns may be, and when I was asked about my interest in this position, my response was, this is a very treacherous opportunity because of the multiple opportunities for potential failure, which in my estimation exceed the opportunities for success. And so, with all due respect and talking in the language that we're talking here as a civic body, you're talking to some folks who are very much aware and acutely aware of the worries that you have. If there is anything that y'all may wish to look at, it is the degree to which you would wish to inject yourself into the oversight of expenditures by the cities and counties. Now again, this commission does not have any enforcement mechanism to insist on the expenditure of money one way or the other. What we can insist upon is a steady and regular flow of expenditure information which assures that we have answers as to where the money is going with verified, certified expenses to ensure that there is transparency. I believe we have to do everything that we can to make ourselves available to coordinate cooperatively and helpfully with the cities and counties so that they, number one, understand all of the complexities of the addiction and recovery ecosphere which has developed within this state over the past 10 years, and then make sure that they have a good, clear set of choices from which to choose as to how they allocate those resources, either within the existing infrastructure or through the development of a more locally tailored solution that is nonetheless effective. And I think that we have the ability and certainly the expertise within the number of 11 to provide them with that. Only thing we could do is offer the opportunity, and hopefully they will feel convicted to follow through on it.
Very thorough answer. Thank you. Thank you, Mr. Chairman.
Representative West.
Wow. You've really got your work cut out for you, and I don't think you have. I know your eyes are open, but what might be revealed to you will be horrifying. I've been in the General Assembly now. This is my 24th year. And you talk about fighting corruption in this state. I took on some really ugly battles, and at one point even a previous governor told me I better watch my back. When you go after area development districts or judge execs or any of those local level people, there's a fiefdom, and they don't want anything to leak. It's dangerous when you start opening war chests that have been profit centers for individuals in local communities. And I'm not saying that that's going on now. I'm saying it was going on then, and since then, nobody has tackled the subject. I am wondering if there's any entity that's public that I trust. I trust our public health departments that are woefully underfunded. That might be a good source of revenue streams. And I also trust our universities. There are so many eager students with brilliant minds that would do studies just for grade credits. If you really needed some in-depth research, our universities would have students that would be screaming to have the opportunity so they could start building their own future profession through their degrees. I'm just throwing that out. I'm sorry if I've offended anybody, but I tell you, I know what the wounds are, I know what their skeletons are, and I know what the entities are that have, in my past, been real hindrances to transparency.
You've not offended anybody at this table. And I would go so far as to say that from the outset and at the very beginning of this process, beginning next Tuesday when we have our first commission meeting, all of us have to be very cognizant of the tremendous erosion of public confidence in public institutions that has unfolded to a dramatic degree over the past 30 years. And our very first obligation is to make sure that we establish firm public confidence and trust, not through an entitlement demand, but through a demonstration of our commitment to transparency, accessibility, and understandability of what it is that we're doing.
Representative Wilner.
Mr. Chairman, thank you for the presentation and for such thoughtful answers to these really great questions. The opioid crisis is such a multi-dimensional problem, right? There's the public health aspect and the behavioral health and human services and academic, science and research, public protections, policing. There's so many different pieces and so many different ways to attack this. And I'm just curious if the commission, if the AG's office, if there's a particular philosophy that one approach is better than another, or that there needs to be a balanced multidimensional approach, or how all those, ways of attacking this problem will be balanced in your recommendations.
If we define the evolution of this issue from front to back in terms of how we tackle it, we can break it down into three categories. One is prevention, one is treatment, and one is recovery. I am only one of 11, and the commission collectively will develop the priorities and the way in which those priorities will be addressed. But I think if we look at those three categories broadly, that's where we begin. And of course, there is a significant compliance and reform component that comes and encompasses all of that. Insofar as we're talking about compliance with existing laws and regulations as it pertains to the administration of medically assisted treatment, when it comes to how our laws and regulations are set up to deal with criminal justice issues as they relate to addiction. As you mentioned, this is a multi-dimensional problem. It is a broad universe of issues that we're going to be addressing, and we hope to do our very best to try to change the trajectory of where we have been.
Thank you very much.
Senator Meredith.
Thank you, Chair Bentley. It's a follow-up to Senator Carroll's concerns as well as Representative Westrom. I would throw out maybe the possibility of working more closely with the area development districts, because I'm concerned, I think, Mr. Hubbard, you guys will do your job, there's no doubt about that, but I'm concerned you're just going to be inundated by so many requests that it's going to be impossible to keep track of, and I'm probably most concerned about making sure we don't have redundancy in services. And I would think, since we already have kind of a precedent set in Kentucky with the distribution of funds through area development districts, could this be a big player in this and really make it more timely and more effective and efficient by working through those folks rather than individual political sub-entities? Just a thought.
Thank you for that feedback, and I would appreciate any education you'd like to give me on an individual basis as to how we may achieve that.
All right. Thank you, sir. Appreciate it. Thank you, Mr. Chair.
Representative Weber.
Thank you, Mr. Chairman. Mr. Hubbard, you mentioned just a few minutes ago that the first advisory council meeting is next week.
Yes, sir.
Is that meeting open to the public?
Yes, sir, absolutely.
And what time will they be meeting, and where will they be meeting?
The first meeting will be, and I'll just say it all out here so everybody's got it down. It will be on Tuesday, July the 12th at 1 p.m. at 1024 Capitol Center Drive, Suite 200, Conference Room A. And it is scheduled to go from 1 p.m. all the way until 5. There will be a public notice of the meeting put on the Office of Attorney General website, as well as the agenda. Is that right, Mr. Christopher? And it will be a kickoff. It will be kind of a nuts and bolts meeting, just to kind of get everything set up by way of our subcommittee structure, our proposed meeting dates, who's going to serve on certain subcommittees, and adopt the meeting calendars so that we can make sure that the wheels are turning as fast as we can get them to go between now and the end of the year.
All right. Thank you for that information.
You're welcome.
The 1024 Capitol Drive is the Attorney General's East Office.
Any other questions? Well, I'll get to. Okay. Representative Westrom, go ahead.
This is my question for you. can you and the Senate chair of this of the Health and Human Services committees recommend that a few members of the General Assembly attend these meetings to kind of be an eye and ear to keep us all apprised of what's going on? That would be very helpful, I think.
At this point, I'll be the only representative there. There's no senators, so I think that'd be a good idea.
Well, you're good enough to attend.
I don't think so. But we're about ready to run out of time, so I'm going to make a few comments, and they're a little different. Of course, I helped structure that bill 427, so if you get a chance to read it, there's 29 funding projects or 29 listings that we put on there, everything from home-based wraparound services to public education. So all those things that's what you were interested in. It's in the bill. And then in the back part of that bill, it tells what the commission can do. It's additional duties and responsibilities. So I tried to be really thorough when we worded that. And there's 6 of those for the commission. I have several points here, and they're all different, so I'll shift another gear, as my wife says. Back when the OxyContin was out there, and I was a pharmacist, a real practicing pharmacist at the time, I asked Purdue Frederick how much they did in OxyContin 80 milligram. The worldwide gross sales of OxyContin 80 milligram was more than the whole horse business in Kentucky. That's how big it was. So that gets in your mind, if you can grasp that, that's how big OxyContin 80 milligram at Purdue Frederick was. The accountability is also in 427. And right now, you guys are already booked to be back here in a year. And you got a big responsibility. I know, and even A&R. You have to go to the cabinet, you have to report to A&R, so there's a lot of accountability there, and we need to see outcomes. Or several of us on this committee are tired of spending money and not seeing outcomes. So that's one of the things that we really want is accountability. Measurable outcomes, too. You were talking about putting people from the university on there, Representative Westrom and Wilner. You know, Dr. Marsh, she's on there. I mean, she's head of the whole shebang over there. But the COVID crisis made the opioid crisis more severe. You know, and I was reading about some other things the other day. Even marijuana, during the COVID crisis, people were separating those 60 THCs to see which one was most powerful. And THCP stands on the receptor side about 31 times longer. So this black market that we deal with and all these derivatives, you know, we got to be ahead of them. We got to change the whole lifestyle up where I live in eastern Kentucky. You know, homes and work and education and rehab are very important to me. So I thank you all for coming today and your presentation. Anyone else have any comments? I think everybody today has got to ask a question. That's good. And so now the public has more information for them too. So with that, I would stand adjourned.